Welcome back to another J. Harris Academy Police Training Roll Call. I'm Joey Scalazzo. Today we're going to be discussing State versus Jaikeem Johnson. This New Jersey Superior Court Appellate Division unpublished opinion decided on April 21st, 2025. Before we jump into the details of this case, let's just review real quick State versus David L. Smith, which is a New Jersey Supreme Court opinion decided June 28, 2022 about window tint. The main statute at issue, 39374, prohibits non-transparent material only on the front windshield and front side windows. It does not apply to 375. The definition of non-transparent is not unconstitutionally vague, and it means that the tint is so dark that officers cannot clearly see people or items in the car through the front windshield or front side windows. So now going into the details of this case, State versus Jaikeem Johnson. On June 17, 2017, Elizabeth police officers observed a red Dodge Charger traveling in the opposite direction. The two occupants in the front seats were wearing black ski masks. The front and rear windows were heavily tinted, but not the windshield. The officers decided to stop the vehicle due to the tinted windows. Officers made a U-turn and positioned the patrol vehicle behind the Charger, which made an immediate left turn and almost collided with another vehicle. Officers activated lights and siren, and the Charger stopped. As the officers exited their vehicle, the driver, front passenger, and rear passenger side doors opened simultaneously, and three black males wearing black shirts and blue jeans exited the Charger. Officers instructed them to stop and get back in the vehicle. They looked back at the officers, slammed the doors, and they ran. Two of the three were caught and searched incident to arrest. A dark-colored ski mask was recovered from the defendant's pocket. Also recovered were two sets of keys that the defendant had thrown on the ground during the pursuit. Search incident to arrest of the co-defendant James Guilford revealed two clear Ziploc bags of marijuana. The third individual was never caught. Officers returned to the Charger. The doors and windows were closed, and a large crowd was forming. The officer could not see into the back passenger compartment through the front windshield. He opened the driver's side door to clear the back of the vehicle as he could not see through the side windows. This was done to ensure that no other persons were inside the vehicle, including the third suspect, and for officer and neighborhood safety. Upon opening the door and sticking his head in the vehicle to clear the back seat for any other parties in the vehicle, the officers immediately observed a black and gray handgun in the driver's door panel. It was immediately apparent that it was a handgun. The officer secured the loaded handgun. The officers then opened the front passenger door and recovered a handgun in the passenger door panel slot. They recovered a third handgun in the right rear passenger door panel slot, marijuana in the center console, and a black ski mask on the rear seat. The defendant filed a motion to suppress, arguing that the motor vehicle stop was unlawful and officers were not permitted to conduct a productive sweep of the vehicle, and the trial court denied that motion. The appellate court ruled on the stop. Based on the credible testimony of officers, the reconsideration court found that they were not able to clearly see the occupants of the vehicle through the front driver's side window of the Charger. Officers testified repeatedly they could not see through the heavily tinted front driver's side window. Officers' testimony was corroborated by the court's review of the photographs of the tinted windows presented at the hearing. The state presented sufficient evidence the tinting on the front side window inhibited officers' ability to clearly see the vehicle's occupants. This established reasonable articulable suspicion for the motor vehicle stop. The protective sweep. The suppression court correctly concluded it was permissible for the officer to conduct a protective sweep of the passenger compartment of the vehicle. The protective sweep doctrine is a recognized exception to the warrant requirement. The police may perform a warrantless protective sweep of a vehicle's passenger compartment where the totality of the circumstances support a reasonable suspicion that a driver or passenger is dangerous and may gain immediate access to weapons. The officer's seizure of the handgun he saw in the driver's side door panel was permissible pursuant to the plain view exception. The defendants claim that the officer exceeded the permissible scope of the protective sweep by opening the front door instead of a rear door lacks merit. There is no reason officers needed to conduct the protective sweep of the passenger compartment starting with the rear doors. The scope of the search did not extend beyond a cursory examination of the passenger compartment. Moreover, Had officers started with the rear doors, he would have still discovered a handgun in the rear door compartment. The appeal is denied. This is another great case out of Elizabeth. This appeal was denied and the conviction was upheld. The search was proper. The stop was proper. Remember, if we're stopping a car because of the fact that we have a window tint violation, that tint on the front driver's side, passenger side, or windshield needs to be so dark that you can't see people or items within that vehicle. You are going to be called upon to testify to that. They're going to want corroboration. They're going to want pictures to be submitted. They're going to want body camera to be able to capture how dark that is. If your body camera doesn't capture it after the arrest is made, go back, roll up those windows, take pictures. It'll be the best thing for you if there ever has to be an appeal in a case similar to this. The second, let's talk about those protective sweeps. Protective sweeps, you're looking for people or items that pose threats to officer safety. We're talking about weapons. In this case, there was possibly an assailant at large. They opened up that door to make sure that there were no other people. That window tint was so dark that they couldn't see inside. They needed to clear that car, make sure that there's nobody else in there. Additionally, if you're going to do a search for weapons under a protective sweep, we need reasonable articulable suspicion. That's less than probable cause. So because of that, we need to make sure that we're only checking compartments capable of holding that item that we are feeling threatened by. If you're looking for a gun, you can't look inside of a small container because a gun wouldn't fit there. The courts will examine that. And because that threshold is lower under reasonable suspicion, if you go further and you didn't have probable cause that there's going to be any type of contraband inside of that vehicle, that search will be suppressed. Excellent job again by these Elizabeth officers. Please continue to watch these videos. Subscribe for more. Stay safe out there. And if you have any questions, drop them below.
This podcast is brought to you by the J. Harris Academy of Police Training. J. Harris Academy of Police Training is based in New Jersey and provides law enforcement training services nationwide for promotional examinations, use of force, supervisory development, and other key areas within law enforcement. This podcast is utilized to discuss key topics occurring within the profession. The opinions and information provided is for entertainment purposes only. In an effort to provide this, we often purposely discuss opposite views and opinions to spark conversation and develop discussion points. The contents of the show and show notes are all copyrighted. All blog posts, podcasts, and show notes that are distributed to the public for free can be redistributed via hard copy or electronic copy for free only if the J. Harris Academy of Police Training is included as the acknowledged author within the actual media that is redistributed. This entire disclaimer also applies to any guests or contributors to the podcast or blog. Under no circumstances shall the J. Harris Academy of Police Training, any guests, contributors to the podcast or blog, or any employees, associates, or affiliates of the company be responsible for damages arising from the use of the information provided.